if there's a court reporter for this argument?
I'm sorry, Your Honor.
Is there a court reporter for this argument? Are you okay there? Okay, just wanted to make sure you're okay there because we're going to be up here as well. We're ready to go.
Thank you. First and foremost, I apologize. I don't know what happened to our computer system, but this was totally off. And it's happened a long time ago, but it happens now again. I don't know how it happens.
Well, we are here,
Here we go.
ready to hear you.
So good morning, my name is Ken Dandar. I represent Mr. Ramsey. And this is a medical malpractice case. And he was sent by his doctor to the hospital for hemoglobin injections. He had an EKG on a Friday night when he got there. And they admitted him to the hospital, but the EKG was normal. Then in the morning around 10 o'clock, his wife's also a highly experienced nurse, retired. He started to have chest pains and she yelled for the nurse and the nurse came in and the nurse brought in the machine to test him, EKG. And she said to them it was abnormal and she was going to tell the cardiologist. Well, lo and behold, she never told the cardiologist. And we know that because in the evening of Saturday, the cardiologist went through the files and noted only one EKG, that was from Friday night, which was normal. There's no notation of anything being abnormal. Sunday, he is seen by a healthcare provider for the hospital. Everything it says is fine, and then around 11 o'clock in the morning on Sunday, he undergoes a surgery. It has nothing to do with the heart. He undergoes the surgery and they discharge him about 2 hours later. He goes home and about an hour to 2 hours at home, he starts having terrific chest pain again. His wife calls an ambulance. The ambulance comes.
Where are the facts of the case? You have three issues on appeal.
Yes.
Could you
I'll just
let us know why
Okay.
we ought to reverse?
Yes.
In fact, Mr. Dandar, let's just see, I think the big crux is the pre-suit letter. So let's focus on the expert that you've retained.
Yes.
And Dr. Stevens, correct?
The Stephens.
Okay,
Yes.
Stephens, D.
D.
Stephens.
Stephens.
D.
Yes.
Stephens,
Yes.
okay. So if you look at Dr. D. Stephens' medical expert opinion, I pulled
Yes.
it up right here. It alleges that Dr. Michael Peebles, Dr. Patrick Mella, and Nurse Alicia Johnson,
Yes.
correct? And his expert opinion basically said that they breached the standard of care
Yes.
with respect to the treatment of your client. So let's take each one of those at a time. And I think the court basically concluded that your doctor was really not qualified to render the appropriate opinion against these three. So let's digest each one. Dr. Peebles, my understanding is he's a medical doctor licensed here in Florida that specializes in gastroenterology.
Yes.
Okay, and then it looks like Dr. Mella is here, I have it right in front of me.
But we didn't go after them.
Okay, so maybe that's why it didn't pull up right now. And so the nurse also, he had some comments about the nurse. So help me out, Mr. Dandar. Why was the court incorrect in coming to the conclusion that your expert was not qualified to render opinions because he was not a gastroenterologist and obviously he was not an expert, that is not a nurse practitioner, so help me out.
Well, he's qualified as a hospitalist for over 25 years and a locum hospitalist within 2 years of this event. So he's qualified to render an opinion on his personal knowledge of nurse practitioners who deal with cardiology patients in particular.
Where in his submission, I know you're arguing that you should have had an hearing, but does it satisfy 766.102 subsection 6, which is to say that let's just presume for the sake of discussion that he satisfied 766.1025. C1. And we get to, which is requirement of subsection 6, a doctor opining about the standard of care for a nurse. And he, by reason of this 1 month of active clinical practice as a hospitalist within the 3 years, has knowledge of the applicable standards of care for nurses as it applies here. Where in the submission does the expert satisfy that requirement?
Well, if it's not in his pre-suit affidavit, it's in subsequent affidavit to be filed, I believe, with this court. See, I have another case up in
In the record,
Tallahassee.
where does he satisfy that he's a physician? Again, leaving aside whether he qualifies under subsection 5C.
Right.
But if he's not providing an expert opinion regarding the standard of care for a physician like himself, right, a hospitalist,
Right.
because the way that the plaintiff is attempting to establish liabilities by way of the nurse's alleged negligence. So where in the submission that is on, that we're dealing with in the record, establishing the qualification of the physician, does it establish that by reason of his 1 month of, I think it was a month, within the 3 years of active clinical practice as a hospitalist, he has knowledge of the applicable standard of care for this type of nurse who
Nurse
you're alleging was
practitioner.
negligent?
Well, it says 25 plus years plus that 1 month. And the
No,
1
but
month
it
is
has to be
within the
3 years.
Yes, that 1 month is in the 3 years. I thought it was more than a month. But if it doesn't say it in the affidavit or his CV, I believe I filed a second affidavit from him. And if it's not in the record, then I'm confusing this with another case in Tallahassee, where we had an appeal, we came back, had an evidentiary hearing, and that's where all this would have come out in the evidentiary hearing, which the judge denied. And the statute's clear.
But I don't want to,
Okay.
I wasn't asking you about
All
that.
right, but if it's not in the affidavit, then I don't know where it is, and I apologize to the court. I have things going on with my mother-in-law at home that took my attention today, but it wasn't on my calendar, so I wasn't ready to come here today. But if it's not in the affidavit, and there's not in the record a subsequent affidavit, then it's not there. And I can't tell you if it's there or not in a subsequent affidavit. But he's saying in his original affidavit that he has all these years' experience over 25 years, plus the 1 month. Has knowledge, personal knowledge of the standard of care of the nurse practitioner in a hospital who's doing these EKGs, and it must report the abnormal EKG to the cardiologist in the hospital. And that wasn't done. I believe he says that she was negligent.
Well, we only assume that he said that because that's why the expert opinion was obtained.
Exactly.
We're asking whether he has the qualifications under the statute to so opine.
He does, because he has all those years' experience working in the hospital. He knows the standard of care of hospital nurse practitioners, particularly with cardiology, because he's board certified in cardiology. So he knows the standard of care. You have to report the abnormal EKG to the cardiologist, and that was not done. Nor did they provide us any of the nursing records to show what was and was not done. So that all this, the expert is waived. We don't provide us all the
So,
records.
but what evidence is there that these records existed that are alleged to not have been provided by Meese?
Well, they still have not been provided, as far as I know. You have to have hospital records of nurses seeing the patient and doing the EKG. And as far as I know, that wasn't provided. We asked for it twice, and the second time was in pre-suit notice.
Let me ask you this. So I'm just maybe satisfying my own curiosity, but would the absence of these notes support your case that the nurse was negligent?
The absence of the notes, we think they're incriminating, that's why they're not being.
No, but would their absence also support your claim that there was the failure to communicate the abnormal EKG?
Yes, because when you don't provide nurses' notes.
So you're alleging that she failed to communicate the abnormal EKG, and then when the hospital says, no, these notes that you believe exist don't exist, you're saying that absolves you of the pre-suit requirement
Yes, always,
when the actual absence of the notes that you purport to have exist and not, and were improvidently withheld itself, their absence would actually support your case that the abnormal EKG was not communicated.
exactly.
Can that be right? I thought your position was, we didn't have to provide the expert because they failed to provide documents.
That's one of our positions,
But
yes.
that was the position, as I understood it. The
But-
hospital says, we produced whatever they was. And now I see a very thin read that you are taking the position, well, there should be other documents.
There should be nurses' notes.
Well, if they say there aren't, now you're taking it to a next step. It's not that they did not produce documents. I don't have to provide the report because they did not create documents they should have.
In the normal course of events, our experts said there has to be hospital nursing notes on this EKG that's very abnormal.
Well, maybe that might go to the issue of negligence, but I'm not sure that is all from the expert.
Okay. So, and the biggest thing is the cardiologist in the hospital who looked over the chart 9 hours later on Saturday did not note there was an abnormal EKG. So that abnormal EKG was either not in the file or it was never reported, or both.
So it was never reported. That might support the contention of the hospital that these notes you think didn't exist.
Well, my client's wife, 35 years of nurse experience, is standing there while the nurse is saying, yelling, it's abnormal, look at this, and running out supposedly to report it, but it's not reported anyway. Now, did we have to provide, can they attack our expert after the statute of limitations run? And the Supreme Court, the 50C, the cases we cite, they're saying, no, you can't. You cannot attack pre-suit inadequacies after the statute of limitations run, because then there's no time to redo it.
How do you respond, Mr. Dander, to the other side that said, because you made a request for an extension, the 90-day automatic extension, and then they're alleging that there was another 90 days. So basically, by the time this issue was brought to your attention, you still had several months to try to rectify that. How do you respond to that?
Well, I disagree with that. I believe, as our brief says, that statute extension had run. It had already run, and I don't think you get to have a second extension. That's why we're not suing the others. We dropped them out because I believe that.
Well, there's an automatic tolling, right?
Well, there's an automatic tolling once you file the
Then you can
extension
pay the filing fee and you get an extra,
for $45.
and that's an extension. It's been described, I think, as an extension rather than a tolling.
All right, it
You
doesn't.
tack it on the end, right?
Right, well, it tags on to the end. Is that what extension, right? I don't know what the difference
I'm
is.
paraphrasing the case law I thought I
Okay.
read.
All right,
But the point is, that's 180 extra days. How do you, maybe we should ask you to walk us through your calculation, since I can say personally, my calculation is that let me back up, and let's just ask maybe more fundamental question in this regard, which is, what is the filing, what is the motion that you believe put you on notice of the failure to comply with pre-suit requirements? Now, the motion that was ultimately granted, I think, was in May, but the first time that this motion, that the defendants asserted this defense, was in January of 2020.
yes, we filed the amended complaint on January 3rd. They filed a motion to dismiss on January 13th of 2020. And that's when they raised it for the very first time.
Why wasn't the statute of limitations still running at that time?
It had expired.
When did it expire?
Well, let's go back.
When did it expire?
I don't know yet. I can't tell you off the top of my head. This happened in September 2017. So September of 2019 plus October, November, December. So it expired in December.
What, no, you just said
That's the
3
first
months,
90 days. You're right. That's the first
the
90
tolling,
days.
right? Automatic tolling.
So then you get an extra 90 days. So I may be incorrect that the statute had not expired. Okay, because we had an extra 90 days. I don't know if did we file an extension?
That's my understanding of that. I don't recall you in your briefing disputing that there was the quote unquote purchased 90-day extension.
Okay. All right. Right. I was pointed out by my co-counsel that there were no nurses notes provided to us, not just the abnormal EKG. There were no nurses notes provided to us. So my expert's working off of his experience that when you have an abnormal EKG because the wife.
Tell us a case in which there's this, he said, she said, you have these records. No, we don't. And which case says, well, we're just going to presume that the plaintiff is correct, that the defendant is hiding something, even though they say we don't have this document, we produce everything we have, and that somehow absolves the plaintiff of complying with pre-suit requirements.
Because the Saturday night cardiology reports mentioning only Friday night's normal EKG.
No, what case says, hey, the defendant is saying we produced everything. The plaintiff said, no, you haven't. I know this exists. You're withholding it. And then the trial court and then the appellate court says, you're right. You don't have to comply with pre-suit notifications because by virtue of accusing them of having a document they say they don't have, you're absolved from complying with pre-suit requirements.
All right.
Mr. Dander,
Case.
Mr. Dander, excuse me for interrupting. I do want you to answer the question, but you're up to 16 minutes of your time. So if you want to reserve some
I want
time.
to reserve, yes, I'm sorry. The case is on Weinstock versus Growth, 629 Southern 2nd, 835. That's from the Fourth Supreme Court, 1993. And NME Hospitals versus Azarati, 573 Southern 2nd, 173 from the second DCA, 1991. 766.2042 the Florida statute says, quote, failure to provide copies of medical records or failure to provide the charge for copies shall constitute evidence of the failure of that party to comply with good faith discovery requirements and waives the requirement of written medical corroboration by the requesting party. Did that answer your question?
I can look at the cases.
Okay. All right, let me, the biggest thing is that when I asked the judge for an evidentiary hearing, which we're entitled to under the statute, he simply turned to me and said, go ahead. I said, Judge, we need an evidentiary hearing so I can bring my expert in. Denied. And that was the end of it. I've never had that happen before. You have to have a real evidentiary hearing, and then the judge can decide if my expert is qualified or not. Thank you.
Mr. Dander, we'll give you about 4 minutes for rebuttal.
Thank you.
May it please the court, Todd Jennings, from Brown versus on behalf of Yathleen, East Countryside Hospital. The first issue.
Since we've asked Mr. Dender that trust question, let's go ahead and deal with that. The request was made for the full medical records of his client. And according to Mr. Dender, everything was provided but for nurses' notes. And if you look at every single medical record, nurses' notes are common. I mean, it's standard. And by virtue of the fact that they're saying they have not received any of the nurses' notes, how can you say that we comply by providing a copy of all medical records to them?
Yeah, thank you for that question. Today is the first day we've heard that they didn't have all of the nurses' notes. Throughout this case, it's been you didn't provide nursing narrative notes. Now, they admit that they received the medical records and the notice of filing, amended complaint, second amended complaint, in their own initial brief, as well as the affidavit of their own expert. Dr. DeStefans in paragraph 9, this is record 305, he says the complete hospital records do not have physician's progress notes except for 7 a.m. progress notes by Dr. Mella. And he goes on because there was no progress note mentioned in EKG. He says critical is that such an abnormal EKG compared to the admission EKG should have been immediately referred to the hospitalist. Dr. Mella the proper way to determine this must be reviewed in contemporary nurses' notes which are missing. And so the whole crux of this is we did provide the medical record. There were nursing notes. The claim that has been perpetuated throughout this case, Your Honor, is that there were no nursing narrative notes, specifically that there were no notes demonstrating the failure of this nurse to report this abnormal EKG to the hospitals. So, you know, with that, we think the Hill Clay case that we cited is right on point. In Hill, the plaintiff sent a request for medical records. The plaintiff received the medical records, went back to the hospital, claimed that there were certain nurses' notes missing for about a 12-hour period. The hospital again produced records. The notice of intent, similar to this case, stated, you know, you've waived the cooperating expert opinion requirement because you didn't produce the full medical records. The hospital maintained that it had produced everything that it had. The plaintiff was in essence trying to get the court to require the hospital to create a record of the alleged injury. In this case, it was a labial tear during childbirth. The plaintiff said, I have witnesses that saw that this tear happened. It was caused by a ring worn by one of the nurses. There should have been a record of this. And of course, the court in Central Florida Hospital versus Hill stated, just because there was an injury doesn't mean there's a duty by the hospital to report that in a record, that you know, the failure of which to produce waives the cooperating expert affidavit requirement. So, you know, we believe that Hill is on point. You know, importantly in Hill, the plaintiff never did any discovery or did anything to actually prove that these allegedly missing records that weren't produced were actually in existence. And of course, that wasn't done here. If you look at the pre-suit, there was no request to inspect electronic medical records. There was no request to take the unsworn affidavit of a representative of the hospital, the records custodian, of any of the nurses or physicians. There was no discovery done after suit was filed to try to determine whether or not these alleged nursing narrative notes actually existed.
Can I ask you about the statute of limitations?
Yes,
You added what I'm presuming is a belt and suspenders argument, but my calculation might be wrong. And that is that because there was a second notice of intent served on another defendant, which told us to all potential defendants, leaving aside whether the existing defendant is a potential defendant if that entity's already been sued, that adds another 90 days because it tolls for everybody, or I don't know, there might be some overlap. But my calculation is that, or I ask you, does the hospital's argument even rely on that? Is that even necessary to get past the January 2020?
no, Your Honor, it's not. You know, our first step is obviously the 90-day tolling period for our pre-suit investigation. That would have ended as the appellant claims around December 15, 2019. The purchased extension under the Medical Malpractice Act automatically adds 90 days to the end.
That gets them about March.
Yes, Your
So in
Honor.
other words, this argument that relies on the existing defendant being characterized as a potential defendant is not necessary to establish that the defense was asserted prior to the running of the statute of limitations.
You're correct, Your Honor.
Let me leapfrog then to the very last issue that Mr. Gendar raised regarding the qualification of his expert. He indicated, and you can see here in the transcript, that he had wanted the court to at least to schedule this for evidentiary hearing. And I know the exchange that was made, that I thought his CV was sufficient. I thought this was sufficient. But if you're questioning that, Judge, then I'm really requesting an evidentiary hearing. Why should we give him that opportunity?
Well, I think if you look at Klein, the case that we cited, the great case that we cited in our response brief, Your Honor, Klein makes it very clear where that you can waive. First off, in our brief, we assert that he was afforded an evidentiary hearing. The court treated as an evidentiary hearing. The trial court judge repeatedly stated as such throughout the proceeding. But that aside, assuming that it was an evidentiary hearing, then Klein comes in. And in that case, the court essentially stated that you can waive your request for an evidentiary hearing by agreeing to the procedure of the court court and then waiting till you're already well into the hearing to request that. That's exactly what happened in this case. Our first motion to dismiss was filed in January of 2020. Then the appellant amended his complaint and filed another motion to dismiss. That was brought for hearing in September along with our co-defendants. That was going to address the same issues that were ultimately addressed by the court in April of 2021. No request or objection to the procedure was made by the appellant at that point. Of course, the motion was granted on different grounds because the complaint was filed without leave of court, was a legal nullity. But then we fast forward, we filed a motion to dismiss after the filing of the second amended complaint in October, and then it's set for hearing in April of 2021. So we're looking at over a 15-month period where the appellant made no attempt to request that this be a special set evidentiary hearing, although it was a special set hearing. At the beginning of the hearing, the court specifically said, ask each parties, do you have anything procedural to address before we proceed? At that point, both parties said, no, Your Honor. At that point, they both agreed to the procedure that had been set forth for that special set hearing. It wasn't until the court had interrogated the appellant pretty in depth in the qualifications of his expert, until after the hospital had presented its rebuttal arguments, that the appellant then requested, well, it sounds like an evidentiary, Your Honor. And I think the trial court made it very clear his reasoning for denying the second hearing and transfer. With regard to the waiver and estoppel argument that was brought in the initial brief, the appellant did have a chance to present it, but that goes to the statute of limitations. The cases cited by appellant, of course, we cited the same cases in our response brief, really stand for the proposition that as long as you raise this issue before the running of the statute of limitations, then it's timely filed and timely presented. The ultimate problem the courts have seen is that if the failure to comply with pre-suit is raised after the statute of limitations, you unfairly prejudice the plaintiff. In Ingrid, for instance, in Hoffman, the defendant did not raise the issue as a defense in his answer from defenses. He did not deny the satisfaction conditions precedent within specificity. The defendant waited until the first day of trial to raise the issue of failure to comply with pre-suit. Of course, the statute of limitations had run. The court stated that unfairly prejudiced the plaintiff. Similarly, Waterman versus Stoll, a motion to dismiss was filed, but the issue of the expert's qualifications weren't raised until the hearing. They weren't raised in the motion, they were raised at the hearing, and that was, of course, after the statute of limitations had run. Both cases specifically cite to the idea of unfair prejudice. And in Hoffman, which I think really spells out why our defenses were timely raised in this case, Hoffman states that specifically that the defendant should have amended his answer in affirmative defenses prior to the running of the statute of limitations. Our second motion to dismiss in this case was akin to amending answer in affirmative defenses prior to the statute of limitations. So we think based on the inclusion, based on the arguments that were raised before the trial court, the evidence that was presented for the trial court, one, the requirement of expert affidavit was not waived because the hospital complied with its obligations under the act. Two, the statute of limitations had not run when we filed our second motion to dismiss. Three, we timely filed that motion to dismiss because it was filed before the statute of limitations had run. And four, an evidentiary hearing was presented, was permitted. The appellant had an opportunity to present evidence on his expert's qualifications. He was specifically asked what else he would have presented, and he said, I've got nothing else, Your Honor. And lastly, even if he was denied an evidentiary hearing, the appellant waived that through his actions. And so we would ask that the court affirm the trial court's ruling.
Thank you, Mr. Justice. Stand up.
Yes. The fact that the abnormal EKG on Saturday morning is not in the records is confirmed by the cardiologist that Saturday night, not mentioning it at all. She just saw the good one on Friday night. However, after his discharge on Sunday, and after he was taken to another hospital to save his life, that evening, this party, Reese Hospital, has a cardiologist looking at his records, and then they see the abnormal EKG, which was put in his file after they found out he had a major heart attack, and another, Dunedin Hospital, which is all the same here. They saved him, the EMS saved him on the way. So the abnormal EKG is real, it's in the record, but it's only reported on Sunday night after he has his major heart attack. So somewhere, this nurse in the hospital failed to communicate with anyone on the abnormal EKG. And that's why they should be liable. But as far as the expert goes, we should have an evidentiary hearing. When the judge turns to me and says, go ahead, and I said, Judge, I need an evidentiary hearing with my expert here. Denied. That's violates the statute, it violates the Supreme Court decisions that we cite. We needed.
What was the
evidentiary hearing.
expectation for what would happen and what would be adjudicated and how that adjudication would take place on that day?
I'm sorry. I missed
What was the expectation going into that hearing that would, for what would happen?
The judge would grant my motion for an evidentiary hearing, and then we would schedule an evidentiary hearing. It's the same thing that happened in Tallahassee. The judge just looked at an affidavit. and
So
said,
you're telling me that your expectation for that hearing was a motion for evidentiary hearing set? I'm not quite following. What did you expect to happen on the day?
The motion was pending. The motion.
Motion for,
Evidentiary hearing was pending, is my best recollection, yes.
you're saying there's when you went to court that day,
Yes,
what was the motion that was to be heard that day?
can't recall, but I believe it was.
But you were saying there was a pending motion
Motion to
to
dismiss.
set an evidentiary hearing at a later date that was pending at the time you went to court on that day. And on that day, I'm asking you what you went to court to have heard
That day.
on that day.
And that day were the two defendants' motions to dismiss concerning my expert witness. And I said, Judge, we have, I believe, a pending motion.
How did you expect that would be adjudicated that day?
That the judge would say, schedule an evidentiary.
So you went to a motion to dismiss hearing and thought, going in, I'm going to request an evidentiary hearing to happen at a later date.
Correct, that was only one of the issues on their motions to dismiss. So if I was going in there expecting to schedule an evidentiary hearing, yes. Because you can't have it, you can't comply with statute unless you have an evidentiary hearing.
Didn't your arguments, did you also expect that you would win on your argument that you didn't even need to comply with the conditions precedent because of a discovery violation?
That as well, but I also had pending.
So your fallback argument is if I don't prevail on that, I'm going to ask for another hearing.
Well, my big argument was my complaint stated a cause of action that should not be dismissed. That was number one. Number two is they waived it. They don't get the benefit of an extension for some other party, but they did. And number three is my witness has to have an evidentiary hearing to see if he's qualified or not. But the evidentiary hearing had not been scheduled, I believe the motion had been filed prior to that hearing.
Dan, you're gonna have to wrap it up, please.
And I wrap it up. Thank you.
Thank you. Thank you both.
Thank you.
Take our last case on the docket, Freeman versus